Good evening everyone, Kit here. I'm back with another video. Today I'm going to be reading for you guys. I'm going to be reading the United States Supreme Court BRUSHABER versus Union Pacific Railway Corporation, I think that's what the R stands for. I'm not to be sure. 1916. It was argued / decided in January 24th, 1916. If you like me reading these videos, I have a link down to our PayPal in the description for a private consultation down below for you guys, along with this document for you guys. So for anything to do with you, I'll get right into it. Mr. Chief Justice White delivered the opinion of the court. As a stockholder of the Union Pacific Railroad Company, it was a railroad company, the applicant filled in his bill to enjoin the corporation from complying with the income tax provisions of the Tariff Act of October 3rd, 1913, Second Chapter 1638, Statute at Liberal 166, I'm not sure. Because of constitutional questions duly arising, the case is here on a direct appeal from a decree sustaining a motion to dismiss because no ground for relief was stated. The right to prevent the corporation from returning and paying the tax was based upon many advertisements as to the repugnancy of the statute to the Constitution of the United States, for the peculiar regulation of the corporation to the stockholders, and their particular interest resulting from many of the administrative provisions of the Assailed Act, of the confusion, wrong, and municipality suits, and the absence of all means of redress which would result if the corporation paid the tax and complied with the act in other respects without protest, as it was alleged it was its intention to do. To put out of any way of question of jurisdiction, we at once say that in view of these advertisements and the ruling in Pollock versus Farmers, Loan & T, sustaining the right of a stockholder to sue and restrain a corporation under proper advertisements from voluntarily paying a tax charged to be unconstitutional on the ground that to permit such a suit did not violate the provisions of 3224 revised statutes against enjoining the enforcement of taxes. We are the opinion that the contention here made that there was against enjoining of enforcement taxes no jurisdiction of the cause, since to entertain it would violate the provisions of the revised statutes referred to is without merit. Before coming to dispose of the case on the merits, however, we observe that the defendant corporation, having called the attention of the government to the pendency of the cause and the nature of the controversy, and its unwillingness to voluntarily refuse to comply with the act assailed, the United States as amicus curiae has the bar been heard both orally and by brief for the purpose of sustaining the decree. Aside from advertisements as to citizenship and residence, recitals as to the provisions of the statute, and statements as to the business of the corporation contained in the first 10 paragraphs of the bill advanced to sustain jurisdiction, the bill alleged 21 constitutional objections specified in that number of paragraphs or subdivisions. As all the grounds assert a violation of the Constitution, it follows that, in a wide sense, they all charge a repugnancy of the statute to the 16th Amendment under the more immediate sanction of which the statute was adopted. The various propositions are so intermingled as to cause it to be difficult to classify them. We are of opinion, however, that the confusion is not inherent, but rather arises from the conclusion that the 16th Amendment provides for hitherto unknown power of taxation, that is, a power to levy an income tax, which through direct shall not be subject to the regulation of apportionment applicable to all other direct taxes. And the far-reaching effort of this enormous assumption will be made clear by generalizing the many contentions advanced in argument to support it, as follows. The amendment authorizes only a particular character of direct tax without appointment, and therefore, if a tax is levied under its assumed authority, which it does not partake of the characteristics cited by the amendment, it is outside the amendment, and is void as a direct tax in the general constitutional sense, because not appropriated. As the amendment authorized a tax upon incomes from whatever source derived, the exclusion from taxation of some income of designated persons and classes is not authorized. Hence, the constitutionality of the law must be tested by the general provisions of the Constitution as to taxation, and thus again the tax is void for want of appointment. As a right to tax incomes from whatever source derived, for which the amendment provides, must be considered as intacting intrinsic in uniformity. Therefore, no tax comes under the authority of the amendment not conforming to such standard, and hence all provisions of the sale statute must be once more be tested solely under the general and pre-existing provisions of the Constitution, causing the state again to be void in the absence of appointment. As the power confirmed by the amendment is new and prospective, the attempt in the statute to make its provisions retroactively apply is void because, so far as the retroactive period is concerned, it is governed by the pre-existing constitutional requirement as to appointment. But it clearly results that the proposition and the contentions under it, if acceded to, would cause one provisions of the Constitution to destroy one another. That is, they would result in bringing the proposition of the amendment exempting a direct tax from apportionment into irreconcilable conflict with the general requirement that all direct taxes be appropriated. Moreover, the tax authorized by the amendment, being direct, would not come under the rule of uniformity applicable under the Constitution to other than direct taxes, and thus it would come to pass that the result of the amendment would be to authorize a particular direct tax, not subject either to apportionment or to the rule of geographical uniformity, thus giving power to impose a different tax in one state or states that was levied in another state or states. This result, instead of simplifying the situation and making clear the limitations on the taxing power, which obviously the amendment must have been intended to accomplish, would create radical and destructive changes in our constitutional system and multiply confusion. But let us, by a demonstration of the error of the fundamental proposition as to significance the amendment dispel, and the confusion necessarily arising from the argument deduced from it. Before coming, however, to the text of the amendment, to the end that its significance may be determined in the light of the previous legislative and judicial history of the subject which the amendment is concerned, with a knowledge of the conditions which presumptively led up to its adoption, and hence the purpose it was intended to accomplish, we make a brief statement on those subjects. That the authority conferred upon Congress by 8 of Article 1 to lay and collect taxes, duties, imposts, and exercises is exhaustive and embraces every conceivable power of taxation, has never been questioned, or if it has been so often authoritatively declared as to render it necessary only to state the doctrine, and has also never been questioned from the foundation without stopping presentively to determine under which of the separate headings the power was properly to be classed. That there was authority given as the part was included in the whole to lay and collect income taxes. Again, it has never moreover been questioned that the conceded complete embracing taxing power was subject, as far as the respectively applicable, to limitation resulting from the requirements of art, that all duties, imposts, and exercises shall be uniform throughout the United States, and to the limitations of art that taxes be appropriated among the several states, and of art that no capitation or other direct tax shall be laid, unless in proportion to the census or enumeration herein directed to be taken. In fact, the two other great direct tax shall be laid, unless in proportion to the census of enumeration herein directed to be taken. In fact, the two great subdivisions embracing the complete and perfect declaration of the power to tax and the two correlated limitations as to such power were thus aptly stated by Mr. Chief Justice Follett in Pollack v. Farmers Loan, in which the matter of taxation, the Constitution recognizes the two great classes of direct and indirect taxes, and the rule of uniformity as to duties, imposts, and exercises. It is to be observed, however, as long ago pointed out in VC Bank versus Fennell, that the requirements of apportionment as to one of the great classes of uniformity as to other classes were not so much a limitation upon the complete and all-embracing authority to tax, but in their essence were simply regulations concerning the mode in which the plenary power was to be exerted. In the whole history of the government, down to the time of the adoption of the 16th Amendment, leaving aside some conjectures, expressed the possibility of a tax lying indeterminate between the two great classes, and embraced by neither. No question has been anywhere made as to the correctness of these proportions. At the very beginning, however, those arose differences of opinion concerning the criteria to be applied in determining in which the two great subdivisions of tax would fall. Without pausing to state at length the basis of the differences and the consequences which arose from them, as the whole subject was elaborately revived in Pollack v. Farmers Loan at T & Co., he made a second condemned statement, which is in substance taken from what has said in that case. Early the differences were manifested in pressing on the one hand and opposing on the other. The passage of an act levying a tax without appointment on carriages for the conveyance of persons, and when such a tax was enacted, the question of its repugnancy to the Constitution soon came to this court for a determination. Hilton v. United States was held that the tax came within the class of exercises, duties, and imposts, therefore did not require an appointment. While this conclusion was agreed by all members of the court who took part in this decision of the case, there was not an exact coincidence in the reasoning by which the conclusion had been sustained. Without stating the minor differences, it may be said with substantial accuracy that the divergent reason was this. On the one hand, the tax was not in the class of direct taxes requiring apportionment, because it was not levied directly on property because of its ownership, but rather on its use, and was therefore an exercise, duty, or impost, and on the other, that in any event the class of direct taxes included was only taxed directly levied on real estate because of its ownership. Putting out of view the difference of reasoning which led to the concurrent conclusion in the Highland case, it was undoubted that it came to pass in legislative practice that the lines, but rather on its use, and it was therefore an exercise, duty, and impost. Read there already. Putting out the difference of reasoning which led to the concurrent conclusion in the Hightown case, it would undoubtedly came to pass in legislative practice then the line of demarcation between the two great classes of direct taxes on the one hand, exercise duties, and imposts on the other, was amplified a ruling in that case. It was accepted and acted upon. In the first place, this is shown by the fact that wherever, and there was a number of cases in that kind, a tax was levied directly on that real estate or slaves because of its ownership. it was treated and coming within the direct class and apportionment for is provided for, while no instance of apportionment to any other kind of tax is afforded. Again, the situation is aptly illustrated by the various acts taxing incomes derived from property of every kind and nature which were enacted in the beginning of 1861, lasting during what may be determined as Civil War period. It is not disputable what later taxing laws were classed under these head of exercises, duties and imposts, because it was assumed that they were of that character inasmuch as through putting a tax burden on the income of any kind, including that derived from property, real or personal, they were not taxed directly on property because of its ownership. And this practical construction came in theory as to be accepted one, since it's adopted without dissent by the most eminent of the text writers. I'm gonna get it off here, guys. I'll see you guys in part 2 of this court case. Like, subscribe, and I'll be pinned by demonstration along this document if you guys want to read it. Bye.